Welcome to MetroSTL. I'm Charles Jaco. Today, we're pleased to be joined by St. Louis County Prosecuting Attorney Wesley Bell, and we're talking about something unusual. Prosecutors usually deal with trying to prove someone is guilty, but there are cases when people have been wrongfully prosecuted and innocent people are in jail. And that was the point of a new piece of state legislation, SB Senate Bill 53. Mr. Prosecuting Attorney, why was something like Senate Bill 53 necessary?
I think it's important as prosecutors that, one of the responsibilities that we have are public safety. And that means there are times when we recommend that individuals go to jail. And if we're going to um, take away individuals' liberties, then we have to have safeguards in place to make certain that if we get it wrong, that we can right that. And so we established our conviction incident review unit for that very purpose. And this new legislation gets us in the right direction, that in the direction that we need to be going, to make certain that we are, just to put it out there, just making sure that we get it right.
Now, as I understand it, and please correct me if I'm wrong, this would take place on appeal. In other words, you or some other prosecutor has prosecuted a case, guy's been found guilty, he's in jail. New evidence comes up, DNA, eyewitnesses lying, something indicating that the guy may very well be innocent. So it goes to appeals. Now, what is new about this that didn't exist before in Missouri law? I would assume there was a mechanism before to say, for someone to raise their hand and say, hey, we think this guy was wrongfully convicted.
So prior to this law, it wasn't clear whether there was a clear path for prosecutors to be able to have standing to bring a case to a court saying this individual was wrongfully prosecuted and convicted. And so now what this law is doing, it's giving us a clear path. Essentially, we have standing, and now it's recognized and memorialized in law to be able to bring that information to a court, and for a court to review that process. Because with any legal matter, an individual has to have standing. If you're in a car accident and with Joe, Jane can't sue you. Joe has to sue you. And in a criminal matter, if you're bringing a wrongful conviction in this case, prosecutors technically, based on the case law, did not have standing to bring it after, other than habeas corpus and other things like that. But prosecutors didn't have a clear path for standing to be able to bring it. And I think that that was a miscarriage of justice. Obviously, the individuals or our offices who are prosecuting these cases have intimate knowledge of these cases, at how they're prosecuted, and evidence, be it new evidence, old evidence, being able to look at evidence with fresh eyes. And now when we discover travesties like this, travesties of justice, I should say, we do have a clear path to be able to get those matters in front of a court.
Now, my understanding was previously only the attorney general had standing to bring these in the appellate court. And in many cases, that became nothing but politics. If you had a hard line, quote, law and order Republican attorney general, looking at you, Eric Schmidt, who said, no, I'm not appealing for anybody. If they're guilty, they're guilty. Chances are that none of these cases would ever be even heard. But now individual prosecutors like you can come forward and say, we think this guy was wrongfully convicted.
Exactly. And to be fair, these were kind of issues that had not been litigated, and so there wasn't a clear understanding of what we could or could not do. But based on the court rulings, the most recent court ruling, but that was not, that started with the Lamar Johnson case. Essentially, prosecutors did not have standing after it got past a certain point with respect to the appellate process. And so, this this essentially clears that gray area, clears that, gives us, gets that blind spot out of there. And I think this was the right decision. And I'm glad we were able to work with legislators directly with our office, and working with them directly to get this legislation, and help with the language on this legislation, because it's important. And I think it was the right call.
Now, I'm glad you brought up the case of Lamar Johnson, a man in the city convicted in the early 90s. Your counterpart in the city, Kim Gardner, has maintained, along with Barry Scheck's Innocence Project, that Lamar Johnson is innocent of the crimes. And yet the Missouri Supreme Court and several appeals courts said it's been 20 some years or more. It's really too late now to do anything. Under this new law, does it mean that Lamar Johnson might actually have a chance of going free if Kim Gardner was able to go and argue as innocent, or is Lamar Johnson going to stay in prison for the rest of his life?
In defense of the Missouri Supreme Court, we all are limited by the law. And as the law reads, I think that they got it right. That said, which I think was included in the Supreme Court's ruling, is that, hey, this is an issue that the legislature needs to look at, and they kicked it to them, along with other organizations, talking and reaching out to local legislators. We were able to get this legislation done. And so, again, there's a lot more that we need to do, but this is definitely a step in the right direction. And to your point, there is a clear path now. And I think that that's so important, because, again, few know a case is a random case as well as the prosecutors, how it was prosecuted, the strength of the evidence. And I just think it's important that we take an oath to uphold justice and to bring justice. We don't represent necessarily a client, as a defense attorney would do, and God bless them, they do great work too. But we represent justice, and it's important that we are able to correct injustices.
Speaking of injustices, and this is in many ways more guesstimate than anything else, what percentage of people, has anyone studied it? Does anyone know, who are behind bars right now, I mean, serving prison time, are actually innocent of the crimes they were convicted of, and could use something like this? Is it just a tiny fraction of people, or is there a significant percentage of people who are behind bars who didn't do it?
So, I mean, there's no way to know the exact number, because, anyone that's sitting behind bars, as the saying goes, they all believe that they're innocent. And but here's how I would respond to that. One is too many, Charles. One is too many. Our criminal justice system is designed that we would prefer 100 people go free than one innocent person lose their freedom. And so I would argue that if the result of this law is that one person that we found has been wrongfully convicted is set free, then I think it's worth it. That said, we know the numbers are going to be higher. Currently, with our conviction incident review unit, we have somewhere around 200 individuals who have applied with our office, alleging that they have been wrongfully convicted. Now, we don't anticipate all 200 are going to be are actually, in fact, innocent. That said, though, there's about 25% of those that we are actively at least investigating. Again, we're still undergoing going through that process, so I can't say what the outcome will be. But I mean, that's a significant number that we've identified that are at least worth a second look.
Surprising to me that the extremely conservative Missouri legislature would pass a bill like this that a lot of progressives have wanted passed for years. Now, admittedly, it was attached to one of the right-wing hobby horses, which was getting rid of the residency requirement for police officers in Kansas City. but there still had to be a lot of bipartisan consensus, including with some extremely conservative Republicans, that something like this, reviewing convictions and seeing if people were innocent, was actually a good idea. Did that surprise you?
You know, it's a mixed bag. I think we politicize too many things in this country, and there are certain things that just should not be politicized. And the criminal justice system should never be criminalized. We should all be on the same page to make certain that individuals' rights are not abused. That if we are putting people in jail, that we're getting it right, and that we're preparing people to be released from jail, because the overwhelming number of people in our jails are not in there for life sentences and are going to return back into society at some point, and we need to prepare them for those things. Unfortunately, to your point, we do politicize a lot of things in this country. And so one thing that we have seen in our current our polarized political landscape is that there are a few areas that we have seen some bipartisan cooperation and collaboration, and criminal justice reform has been one of them. Do I think that there's enough? No. Do I think that we could do a lot more with respect to working together to push for criminal justice reform and policies? Absolutely, there is more that we can do. But I'm not completely surprised that there's been some movement, because we know there's a lot of our friends on the right that have been championing criminal justice reform. So not completely surprised, but again, and I just got to reemphasize, we got so much more to do. This is the first of 1,000 steps.
The final question, Mr. Prosecutor, you've got a lot more to do, but you have to be encouraged that certainly since you were first elected, since Kim Gardner is first elected, criminal justice reform painted with a broad brush, whether it's police reform, prosecutorial reform, judicial reform, has actually made some progress in this country, and indeed has become top of mind for a lot of people to discuss in terms of looking at the fight against crime and looking at criminal justice from a different angle. That's got to be encouraging to somebody like you who has run on a platform of reforming the criminal justice system.
You know, and I have been very encouraged that we've seen that narrative slowly start to change. It initially, when I was running for office, it was, oh, he just wants to let everyone out. And when we talked about diversion and alternatives to incarceration, it was the same response. We're not seeing that as much anymore. I think, you know, we've been, not just me, but a lot of stakeholders have been really hammering the message that, you know, for those who commit violent crimes, yes, they have to be held accountable. For those who commit serious crimes that harm people, they have to be held accountable. But there's a whole bag of individuals, a majority of individuals who come through the criminal justice system who just need help. They haven't committed a serious or violent crime. They're struggling with substance use disorder. They're struggling with mental health issues. And by and large, the public is starting to recognize that and see that, particularly with the opiate issues that we've seen throughout not only St. Louis County, but the region. And so, yeah, it is encouraging that the average citizen seems to get this and understand this and actually show up to the polls and vote for this. So yes, again, I'm never going to get comfortable, because again, we still got more to do, but yeah, I am encouraged.
St. Louis County Prosecutor Wesley Bell. Mr. Prosecuting Attorney, thank you very much for joining us. We appreciate your time.
Always a pleasure. Thanks for having me.